Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in United States Fish and Wildlife Service versus Sierra Club, certiorari to the United States Court of Appeals for the Ninth Circuit. If you'd like to support the podcast, please listen to the end of the podcast. This was argued November 2nd, 2020, decided March 4th, 2021. The Environmental Protection Agency, EPA, proposed a rule in 2011 regarding cooling water intake structures used to cool industrial equipment. It's 76 Federal Register 22174. Because aquatic wildlife can become trapped in these intake structures and die, the Endangered Species Act of 1973 required the EPA to consult with the U.S. Fish and Wildlife Service, FWS, and National Marine Fisheries Service, NMFS, together the services before proceeding. Following this required consultation, the services prepare an official biological opinion, known as a jeopardy or no jeopardy biological opinion, addressing whether the agency's proposal will jeopardize the existence of a threatened or endangered species. 50 CFR section 402.14 h1 IV. Issuance of a jeopardy biological opinion here would require the EPA to either implement certain alternatives proposed by the services, or to terminate the action altogether, or to seek an exemption. 16 U.S.C. sections 1536 b 4 g and 1538 a. After consulting with the services, the EPA made changes to its proposed rule, and the services received the revised version in November 2013. Staff members at NMFS and FWS soon compiled draft biological opinions, concluding that the November 2013 proposed rule was likely to jeopardize certain species. Staff members sent these drafts to the relevant decision makers within each agency, but decision makers at the services neither approved the drafts nor sent them to the EPA. The services instead shelved the draft opinions and agreed with the EPA to extend the period of consultation. After these continued discussions, the EPA sent the services a revised proposed rule in March 2014 that differed significantly from the 2013 version. Satisfied that the revised rule was unlikely to harm any protected species, the services issued a joint final no jeopardy biological opinion. The EPA issued its final rule that same day. Respondent Sierra Club, an environmental organization, submitted requests under the Freedom of Information Act, FOIA, for records related to the services' consultations with the EPA. As relevant here, the services invoked the deliberative process privilege to prevent disclosure of the draft biological opinions analyzing the EPA's 2013 proposed rule. The Sierra Club sued to obtain these withheld documents, and the Ninth Circuit held that the draft biological opinions were not privileged because even though labeled as drafts, the draft opinions represented the service's final opinion regarding the EPA's 2013 proposed rule. The Supreme Court held the decision is reversed and remanded, and Justice Barrett delivered the opinion of the court. The deliberative process privilege protects from disclosure under FOIA in-house draft biological opinions that are both pre-decisional and deliberative, even if the drafts reflect the agency's last views about a proposal. FOIA mandates the disclosure of documents held by a federal agency unless the documents fall within certain exceptions, 5 U.S.C. section 552b. One of those exceptions, the deliberative process privilege, shields from disclosure documents reflecting advisory opinions and deliberations comprising the process by which the government formulates decisions and policies. See NLRB versus Sears Roebuck. The privilege aims to improve agency decision-making by encouraging candor and blunting the chilling effect that accompanies the prospect of disclosure. The privilege distinguishes between pre-decisional deliberative documents, which are exempt from disclosure, and documents reflecting a final agency decision, and the reasons supporting it, which are not. See Renegotiation Board versus Grumman Aircraft Engineering Corporation, a document does not represent an agency's final decision solely because nothing follows it. Sometimes a proposal dies on the vine or languishes. What matters is if the agency treats the document as its final view and concludes the deliberative process by which the governmental decisions and policies are formulated, giving the document real operative effect. See Sears again. The deliberative process privilege protects the draft biological opinions from disclosure because they reflect a preliminary view, not a final decision, about the EPA's proposed 2013 rule. The administrative context confirms that the draft opinions were subject to change and had no direct legal consequences. Because the decision makers neither approved the drafts nor sent them to the EPA, they are best described not as draft biological opinions, but as drafts of draft biological opinions. While the drafts may have had the practical effect of provoking EPA to revise its rule, the privilege applies because the services did not treat the drafts as final. The decision below is reversed and remanded. Justice Barrett delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Kagan, Gorsuch, and Kavanaugh joined. Justice Breyer filed a dissenting opinion, in which Justice Sotomayor joined. Thank you for listening. If you'd like to support the podcast or me as I work my way through law school, find me on Patreon or follow the PayPal link in the show notes.